that Maine is one of the 3 states in the country with the strongest home rule laws in the country. I said, oh, all right. So what I'm going to do is tell you what the Maine home rule law is and a little bit about why it's so strong. And then I will read the law that Heather was talking about. So in 1969, the people of Maine voted for home rule in Maine. Before the 60s, it wasn't very common in the country, and there was sort of a rash of people passing usually laws, but in Maine, we put it in the Constitution. That's one of the things that gives us a stronger basis for home rule law. And so that was in 1969. One of the things that was established then was that the legislature needed to pass laws that supported the home rule acknowledgement in our Constitution. And so this is what they passed. It's called Ordinance Power. It says any municipality, by the adoption, amendment, or repeal of ordinances or bylaws, may exercise any power or function which the legislature has power to confer upon it, which is not denied either expressly or by clear implication, and exercise any power or function granted to the municipality by the Constitution of Maine, general law, or charter. The first piece is called liberal construction. It says, this section, being necessary for the welfare of the municipalities and their inhabitants, shall be liberally construed to effect its purposes. That means that unless something is specifically banned, towns are specifically banned from making a law on something, that's the explicit that the first part of this talked about, either expressly or by clear implication. So explicitly, the state can say towns cannot change our laws on this. So think of things that are fairly common. Like, we couldn't have every town setting their own speed limits. People would go crazy, that sort of thing. We'd still speed, but that's that's a different issue. But there are things that the state does specifically take control of. But under liberal construction, you can do anything else. If your town wants it done, you can pass an ordinance to do it. And there's procedures for that, but it's like, okay, what do you think you need in your town for the safety, health, and well-being of your residents? And you can do that. The second part is presumption of authority. And that says there is a rebuttable presumption that any ordinance enacted under this section is a valid exercise of municipalities' home rule authority. So if you think that your ordinance might be a little too crazy or something, well, that's covered in the first one. You can pass it anyway. The second one says there's a rebuttable presumption of validity. That means that the state has to prove that it's not valid. You don't have to prove that it is. And the state proves that it's not valid when the Supreme Court, the state Supreme Court, makes a decision regarding the ordinance. In the Dan Brown case, the state Supreme Court explicitly said that they were not going to preempt the ordinance. Ralph Chapman, our representative from the very beginning, had told us that the courts don't like dealing with constitutional issues, which is what we've raised in the ordinance, and so they will do anything to avoid that. And that's what they did. And they did that in the local court and also at the Supreme Court. They came up with a reason. Locally, they said, well, milk isn't food, so it's not covered under the ordinance. So but that wasn't a scientific definition. It was just the excuse they gave that they didn't have to exempt or preempt the ordinance. And then the Supreme Court had a different excuse. So that's under presumption of authority. Finally, the standard of preemption. The legislature shall not be held to have implicitly denied any power granted to the municipalities under this section unless the municipal ordinance in question would frustrate the purpose of state law. So that Other states have passed other requirements that towns would have to meet in order to consider an ordinance valid. Things like one of them is the occupation of the field. If the state in some way, not explicitly in law, but just through general practice, has determined that they're in charge here, that can be used to deny the validity of the ordinance, but not Maine. There are a couple of other things, too, that some states use. But in Maine, if the ordinance does not frustrate the purpose of state law, they won't preempt it, okay? So